Yes. Yes, we'll start with a quick introduction. My name is Martha Kome, the chairperson of Judicial Service Commission. I welcome you for this interview.
Good afternoon.
Good afternoon.
Isaac Ruto is my name, also Vice Chair.
Thank you, Commissioner.
Good afternoon, Council. Jacqueline Nguchi, Commissioner. Welcome and all the best.
Thank you, Commissioner.
Good afternoon. Good afternoon. Charity Kisutu, Commissioner. Welcome.
Thank you, Commissioner.
Good afternoon, Omwanzo Bati. Karibu.
Asante sana, Commissioner.
Good afternoon, Jokindongo.
Good afternoon, my lady. Thank you.
Good afternoon, Council. Anthony Mrima, karibu sana.
Thank you, my lord.
Good afternoon, Wakili Fatuma Sichale. Karibu sana.
Thank you, my lady, Commissioner.
Good afternoon. You are welcome. My name is Oluwande Evali.
Thank you, Your Honor. Commissioner, thank you.
Good afternoon, Dorcas Odwor, Senior Counsel and Attorney General. Welcome.
Good afternoon, Madam AG. Thank you.
Yes, thank you, Honorable Commissioners. We'll start with you telling us your county and your ethnicity.
Madam Chief Justice, my county is Kericho County and my ethnicity is Kipsigis.
Kipsigis.
Yes, my lady.
Very well. We will now start the interview, but we want you to be very relaxed and make yourself very comfortable because we just want to have a conversation with you to get the very best out of you.
Yes, my lady.
If you could start by telling us, what motivated you to apply for this position, and what special attributes are you going to bring to this position if you are successful? I believe you have studied the High Court.
Yes.
What challenges do you think are facing the High Court, and what innovation or innovative ways would you employ to deal with those challenges? You have 5 minutes.
Thank you, Madam Chief Justice. As per the documents before you, Madam Chief Justice, I have been in practice for the past 20 years or so, and at least I was admitted in the year 2005. And my lady, throughout my practice, I have been in both public service as well as private service. And I split that public service and private service almost in half. And while at the private service, my lady, I got to interact with people from different walks of life. I got to represent accused people. I got to represent claimants in constitutional petitions. I got to do a little bit of a little bit of family law and succession, and a little bit of criminal, and very little of insurance. After that, I was motivated to join the public service, where I joined the Department of Prosecutions. I joined the ODPP way back in 2014. And I joined the DPP as a prosecution counsel, and in that I was prosecuting various offenses as per the DPP according to how they came. After that, my lady, I transitioned to the Kenya Revenue Authority, where I interacted with a very new field, which was tax. I had never practiced tax before, but then it gave me a new perspective also on public service, because this is a high, I would say a place where it is looked at by the public in a different light compared to other public bodies. I think we rank in the same place as the judiciary. We are in the limelight a lot, but then it also gave me a chance to interact with various stakeholders, and my lady, it has been an experience that I have gained through various interactions. First, my lady, I was appointed as integrity assurance officer, and my lady, that gives me an edge when it comes to protecting integrity. I was tasked with coming up with corruption measures, risks, and how to mitigate these risks, how to address the risks under the integrity program. I was also appointed as a performance productivity mainstreaming committee member to look at the performance of KRA, how to improve our own performance. And my lady, the motivation now comes in when I realize that public service is it is self-service, and it takes a lot of sacrifice from someone, from myself, and that is the motivation that I bring here. And I also look at what I have gained through the experience, and I am using that experience to give back through adjudication. And I'm also giving back through, because I have been in a position where I have been both for the accused person as well as the prosecutor. I have been both in applicant as well as the government on this other side, and it has given me a unique view of both sides. And now on this other side, I'm able to appreciate both sides of the coin, and I believe I am now equipped to give that adjudication. The challenges that I see facing the High Court, I would say, is a backlog currently, and because it is an issue that even us practitioners are suffering from that particular issue, we would like to see a situation where we have reduced that backlog to at least 3 years. The challenges in backlog they have been addressed by sending matters to the ADR or council-to-council negotiation and finding ways in which we can reduce that. But I also noticed that while this is going on, while parties are at ADR and the matter is pending before ADR, we do not take directions on how to proceed with the matter. And at the end of the period given to do ADR, you realize that we now have, and ADR does not materialize, we now have to go back to seeing whether we have complied with Order 11 or whether we have filed records of appeal, whether we have filed submissions, and that alone is wasting time. So I hope that when I do join, then we will have a situation where while matters are ongoing at ADR, we are also taking directions on how to proceed and complying with pretrial measures, so that we do not waste time and come back and say now we need to start now that ADR has collapsed. My lady, I have also been thinking of the innovation of giving a particular judge a file to handle from the beginning, so that we do not have to waste so much time before the DR and let the DR deal with other administrative issues. A judge is able to control that particular matter right from the onset, and then we will be able to save on time.
Very well. Commissioner Omwanza.
Thank you, Chief Justice. Counsel, I want to ask one or two questions.
Yes, Commissioner.
And the first one I want to ask is, which judicial philosophy do you ascribe to, and why?
I would say a realism, or a liberalist point of view with a bias to judicial activism. And this is, as a judge, you're supposed to interpret laws purposively and look at the wider concept of it, look at it from a future perspective, look at it from a positive. You have to expound, but at the same time, you also have to restrict yourself without going into other, say, with respecting the separation of powers.
Okay.
Yes.
Now, when you say with a futuristic, you said you interpret the law with a futuristic. So let me.
The Constitution.
Yes.
Yes.
So my view is, my second question is, what kind of country do you see Kenya in the next 10 years? If then you are interpreting the law with a look into the future.
With a look into the future, the Constitution is not exhaustive. It gives a wide interpretation. I'll give an example of the intersex right now and the whole LGBTQ. It's not in the Constitution, but we see jurisprudence growing every day from other parts of the world, and I believe there will be a time when we might have to incorporate some of these things into our laws. And if you look at the Constitution, it will not mention those particular classifications of sex, but when we come to protecting their rights or finding ways on how we can cohesively live together, then we would need to look at the Constitution futuristically.
Okay. Now, when you, while at it, I want you to look at Article 25. Article 25 of the Constitution.
Yes.
25A. It says that despite any other provision in this Constitution, the following rights and fundamental freedoms shall not be limited. I'm more interested in A, freedom from torture and cruel, inhuman, or degrading treatment.
Yes, Mr. Commissioner.
Yeah. Now, one of the ways this article has been developed,
yes,
is to, for instance, declare that the death penalty is unconstitutional. That's one of the developments that have come out of 25A.
Yes.
The other one, if I can pick it out of my head, is perhaps the removal of corporal punishment from some of the penal, punishments that were provided. Now, in terms of developing this article, what do you think would be the next frontier in covering this freedom from torture, cruel, inhuman, and degrading treatment? And would you say that what was, for instance, described as cruel or inhuman maybe 40, 50 years ago is different from now?
Yes, cruelty, what was there 40, 50 years ago is different. We had 50 years ago, even in, like you had said, removal of corporal punishment. Then it was not, it was seen as punishment. You would be given 50 lashes or 10 lashes, whatever lashes. But right now you are seeing the law is developing to remove, because when you hit someone or you give a lash, because the kind of lashes that were given was not like the way you would punish your child. It was, I don't know the English word, but it's called a nyahunyo.
Okay.
Yes, that is how I see it. And when you talk about development futuristically on cruel torture, I look at it from a national security perspective.
Okay.
Yes.
Okay, my last question is, if you are a trial judge,
Yes.
and a suspect or an accused person is brought before you, and it's proved that they've been subjected to torture, cruel, inhuman, or degrading treatment, what would be the effect of that on a fair trial? Would that poison the trial? I mean, how would you go about that?
It depends on why he was subjected to this trial, to this particular inhuman treatment.
But do you ask? Can you ask why? Can you ask why? Why he was subjected to it? Because already it's prohibited.
It is already prohibited, but if it does not affect the particular trial, what I'm trying to separate is the treatment of this person and isolating it from the trial. If it was two separate incidences, he will still get his judgment and he will still get his remedies for that particular treatment. But if it is separate from the trial, if it was a confession being extracted through the cruel treatment, you see they are linked. But if it is not linked to the particular trial, he will still get his judgment either way.
Okay.
Yes.
All right, thank you.
Thank you, Honorable Chair.
Yes.
Wakili, I think the word you're looking for Nyaunyo is a whip.
Thank you, my lady. Yes.
Now, under Section 107 to 109 of the Evidence Act, the burden of proof lies on the person who is making the allegation. In tax matters, we understand that this is the burden keeps shifting like a pendulum.
Yes, my
Can
lady.
you explain to us what that is, you coming now from Kenya Revenue Authority?
The Kenya tax system is a self-assessing tax system. So we expect that when you file your returns at the end of the period, then you have given us a true reflection of what your tax liability is. And then now, that is where we have Section 56 when it says, then we would now take your information, and if we were to do an additional assessment, then we would say, if you declared, say, 1 million shillings at the end of the tax period, we would look at your declaration. That is where we say the proof is with the taxpayer. And it is a taxpayer now to prove that the commissioner's additional assessment of another 2 million is wrong by provision of documents or payments. So because it is a self-assessing regime, the person has to prove that the tax assessment is wrong by the commission.
So the taxpayer has said, this is the tax that I'm liable to pay.
Yes.
So what happens? It shifts to KRA?
No, it still remains with him, because once he says that this is how much I'm supposed to pay, it does not mean that the liability shifts to us. It only means that I need to verify that you actually owe what you have said that you have owed.
So why is it then said that in tax matters the burden of proof is like it swings?
Yes, it does swing. So in this particular case, when the commissioner issues an additional assessment, the commissioner has used his best judgment, the commissioner has used information from, say, third parties, the commissioner has used perhaps market forces to determine the profit margin in the particular industry. So the commissioner then says, you are supposed to pay this much. Prove to me that that is not the tax liability. And it is all boiled down to that particular self-assessing regime.
So he proves that he does not owe that tax liability.
No, he proves that he is to prove that it is an erroneous tax
So
assessment.
it goes back again to the commissioner.
Yes. Now, if he's able to prove that the commissioner is wrong, then it goes back to the commissioner.
All right, fair
Yes.
enough. Now, I heard you say that you worked in the DPP's office
Yes, my lady.
and that you are a prosecutor.
Yes, my lady.
What's an inchoate offense?
Incoherence offense.
Inchoate. I may not be pronouncing it correctly, but I can spell it for you. INCHOATE.
My lady, I will have to refer. ICIN? Yes.
INCHOATE.
My lady, I will have to refer what that is.
All
Sorry,
right.
I'll take that.
All right. Thank you. That's all, CJ.
Thank you, Honorable CJ, and Wakili once again. Karibu. Now, when you...
Thank you, my lady. Sorry,
Don't
thank you,
worry.
my lord.
Don't worry. When you're having an interaction with Commissioner Mwanza,
Yes, my lord.
If I heard you right, you said that at the moment
Yes.
there is no LGBTQ in the Constitution.
Yes.
said something like that.
Yes, at least
Okay.
from the
No, that's
constitution.
okay. It's okay.
Yes,
It's okay.
yes,
Just a list.
yes.
Now, having said that, you also said that your judicial philosophy is liberalism, drifting towards activism.
Yes, my lord.
Now, do you still believe with that judicial philosophy, do you still believe that the Constitution does not deal with issues of LGBTQ? Or were you talking about it from a textualist perspective?
The Constitution does not look at, when it comes to marriage, the Constitution looks at female and male. It recognizes female and male. When you look at LGBTQ, they want to have a marriage between two people of the same sex. There is no legal standing within which they would get married. However, the Constitution would still protect their rights, irrespective of how they choose to live their lives. They would still enjoy all the rights of the Constitution, save for marriage within two people of the same sex. That's how I see it.
Okay. At least you have confirmed that their rights are guaranteed.
Yes, they are.
In the Constitution.
Their sex orientation is not a factor.
Good. Now, for how long did you work in the DPP's office?
About 4 years.
About 4 years. That's
Yes.
good period. Now, let's look at the removal of the DPP
Yes.
from office. And that takes us to Article 158 of the
it okay?
Constitution. And let's paint this scenario. A petition for the removal of the DPP is filed in the National Assembly. And a select committee is set up to investigate the matter and possibly recommend to the president for the establishment of a tribunal which will deal with the allegations. Now, you have been successful and you are in office as a judge of the High Court in the Constitutional and Human Rights Division. And the DPP rushes to your court alleging that he or she is being subjected to a process, a removal process, which is unknown in law. Would you agree with the DPP, and why?
If that particular process has been conducted to the strict letter of the Constitution, then it would not be an unknown process.
The DPP has come and told you, I've been taken to Parliament, there's a select committee, I'm about to be subjected to that process, but that process is unknown in law. Will you agree with the DPP or not?
No, I will not agree with the
You will not
DPP.
agree?
Yes.
Okay, so according to you, that is the procedure provided for in the Constitution.
Yes, my lord.
Okay, you'll have to look at 158. The procedure may be a bit different. I wish you the best.
Thank you, my lord.
Yes, good afternoon.
Good afternoon, Madam Eji.
From your application, you are the assistant manager in the Legal and Board Services Department, litigation, yeah? Unit.
Yes, Madam Eji.
What is your caseload?
Right now, I have about slightly over 120 cases.
How many are you?
Oh, that is for me as
No,
an
first of all,
individual.
how many are you in the unit?
We are about 40 lawyers.
You are 40.
Yes.
And what is the caseload?
Collectively, I would say slightly below 3,000.
Are you sure?
Yes. Because we are at, when you look at the tribunal,
Let me help you.
Yes.
You have 789 appeals before the Tax Appeal Tribunal, 431 before the High Court, 96 appeals before the Court of Appeal. Total is 1,316. That is in the unit.
I am looking at it from the cases that have already been filed. As at last year, I think we had, the tribunal we had a number of about 1,500. I'm not sure how many we concluded then. Then in the High Court, we also have so many of those translate to appeals to the High Court. I may not have an exact number, but if I look at just the TAT number as well as the High Court number, plus we have a lot. How
many cases were concluded? How many cases did you conclude in the High Court, in the Court of Appeal last year, as at 12th of February?
I do not have that number because we look at a cumulative number.
Okay, the reason why I'm bringing up this is because it looks like there is a lot of backlog. For example, at the tribunal, we still have 794 as at today.
Yes.
And then in the Court of Appeal, only one matter was decided. And the Supreme Court, it's one matter. Therefore, the issue of backlog, just as you talked about the judiciary, seemed to be also at the KRA.
We defined backlog from KRA on a different perspective from how the judiciary defines their backlog. For us, backlog is anything older than 3 years. That is backlog.
But if we are concluding one matter in the Court of Appeal in a year,
we are constrained by the fact that the Court of Appeal runs its own calendar, and we have to wait for the Court of Appeal to give us dates on when these matters can be heard. We do not control the Court of Appeal calendar, so we are not able to ask for a date unless then we do a stakeholder engagement with the President on listing our matters. Yes.
But do you think that is a good record?
No, it's not a good record, Madam.
Okay. Now, secondly, recently there was an article in the newspaper about the works, the outcome or efficiency of the Tax Appeal Tribunal.
Yes.
It was a very, I don't know what to say, but it did not paint a very good picture of the Tax Appeal Tribunal. Did you read it?
No, my lady. No, Madam Ichi, I did not read it.
It was attempting to say that the Tax Appeal Tribunal is not actually doing what it is supposed to do, and it is facing a lot of challenges because the outcomes are not being accepted, or there is no, the justice, I don't want to use the words they used, but they cast aspersions as to the credibility of the Tax Appeal Tribunal. Did you read that article?
I didn't read the article, but when it comes to credibility, we have not experienced any issues. They have been very supportive when it comes to ADR because KRA is big on ADR, at least for the legal department, and they have always given us
In
time.
fact, it is in that ADR also that they really had a problem with.
Oh,
yes.
I am not
You didn't read? Okay.
No, I didn't read.
Okay, finally,
Yes.
then let's go back to your legal philosophy. You talked about being liberal, or you'll use liberalism to interpret the Constitution.
Yes.
But I also heard you talk about national security. Now, liberalism centers on individual rights, liberties, democratic processes, and economic freedom. It actually centers on the individual. While national security is concerned with the existence of the state sovereignty. I'm finding it difficult to connect the two.
No, my issue on national security was that there are jurisdictions, and I'm not talking about Kenya, there are jurisdictions that's where they deal with terrorism suspects. They are subjected to cruel treatment, to perhaps say where a bomb could be or something like that for purposes of national security.
But how did you merge national security with liberal philosophy, which is
protection,
it's a moral, political moral philosophy? How did you merge that with national
protection
security?
of people who may be subjected to cruel treatment in the guise of protection of national security?
But the liberals are also concerned about international norms and rules and
Yes.
international outcomes.
Yes.
So why would there be a conflict?
International norms and all that should not infringe on the person. They should protect the person. That is how I see it.
Okay.
Just one question, CJ. You say that, did you say that in terms of national security, a suspect can be tortured and
No.
that would not matter?
No. What I said is they should not be subjected to that torture, even in the protection of national security.
Okay.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Madam Commissioner.
Okay. What is the difference between national security and national interest and public interest, now that you are discussing about issues of national security?
National interest protects within the nation, within the jurisdiction, while public interest protects the individuals within that particular. So we are looking at more of, in public interest, we're looking at more of the person, and in national security, we're looking at the entity
Not
as
security interest,
national interest.
Yes.
In national interest, we are looking at Kenya as a whole, while in public interest, we are looking at every individual within the jurisdiction of Kenya, so that we are protecting the interest of that particular person as opposed to entities or the government.
Okay, I'll leave it at that. So I've gone through your sample writings. You submitted your LLM thesis and submissions in tax matters. They demonstrate strong analytical ability, clear legal reasoning, and good application of the law to facts across the diverse context. You frame issues well and cite relevant case law. Your tone is professional and measured, so
Thank
I
you.
commend you for that. Unregistered, my question now, unregistered customary marriages are culturally valid, but when you look at the Marriage Act, they are considered voidable. What protection do couples in unregistered customary marriage have in the event they have disputes with regards to the marriage?
Repeat that, please.
Unregistered customary marriages in Kenya are culturally valid. So within our different customs, they are considered valid.
Yes.
But when you look at the Marriage Act, they are considered voidable.
Yes.
So what protection do parties in this form of marriage, the unregistered customary marriage, have when they have disputes that relates to their union? It could be property dispute, alimony, and the likes.
I would say when it comes to property, I would say contribution, depending on how the one contributed towards the property. And I would also look at it from presumption perspective. I think there's a Court of Appeal, there's a Supreme Court decision where the Supreme Court said even where it is not registered, they can demonstrate marriage through long cohabitation, through the intent to show that they had the intention to marry. In this case, customary, there's an exchange of dowry. And the Supreme Court also mentioned that they have presented to the community that they are a couple. So they can use that particular very restrictive guidance by the Supreme Court to come and protect their particular rights as a union.
Thank you. But the Supreme Court didn't focus on the issue of unregistered marriage.
Well, it is unregistered, but when it is protecting that particular union in conflict, then we would not see it as a registered marriage. We would see it as conflict between two individuals.
Okay, you
Yes.
may need to look that out, and I wish you the very best.
Thanks.
Thank you. Are you able to tell us what is the difference between a general election, a fresh election, and a by-election, and what triggers each of these?
A general election is the election that is held every 5 years, my lady. And this is an election that elects the president, the governors, the senators, the MPs, the women rep, and the MCAs. And in the fresh election, this is an election that is held where the presidential candidate does not attain the 50+1 and does not attain the 24 or 25 counties, then we would issue a fresh election, I think, within 60 days. A by-election is one where in, say, a county, somebody dies, say the senator, then a by-election would be held, or an MP in a constituency.
Okay. And what happens where the Supreme Court nullifies a presidential election? What kind of election is that?
That would be a runoff. Sorry, not a runoff. That would be is it a rerun?
Okay.
After.
All right.
Yes.
What is the difference between a spoiled vote and a rejected vote?
A spoiled vote is where a candidate ticks maybe 2 people, or at least more than one, or does not tick within the box. And the other one is where the vote is either placed in the wrong box, or it is torn, or it's defaced.
Okay, so is a spoiled vote counted?
No.
And a rejected vote, is it counted?
No.
Okay, it is actually.
Well, not. I don't think it is counted.
It's in the ballot box.
It's in the ballot box, but it does not constitute the 50+1.
All right, thank you. Thank you very much.
Thank you.
AJ, can I just clarify something? I think, Judith.
Yes, Madam.
I think I have an obligation to clarify what I asked you about the statistics, yeah?
Yes, yes.
So I think apart from the Court of Appeal, actually in other courts, your department has done well, because the success rate is about 93.6. So let me make that clear so that it doesn't come out you're not working.
Thank
so
you.
Apart from the Court of Appeal, in fact, they cleared 2,389 against a target of 25. So I think in other courts you are doing well. So you might be able to assist with the backlog in the judiciary. I wanted to clear that.
Thank you, Thank you, Madam AG. Thank you.
Thank you, Chair. Good afternoon.
Good afternoon, Madam Commissioner.
So I want to read you a quote that I have here. It's from an American jurist. Then I want your take on it and reasons why you believe whatever position you will take. A judge who likes every outcome he reaches is very likely a bad judge.
A bad judge?
Yes. Okay. Stretching for results he prefers rather than those the law demands. I'll read it again. A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands. You got the statement? Yes. Can you tell us what your take is on it and reasons?
Madam Commissioner, this is a judge who decides what he wants without he as a judge you must first look at the law, look at the facts, and then apply the law, apply the facts to whatever, and the outcome is based on those two things and the Constitution. But this particular judge is deciding today, I want to find in favor of the plaintiff, without analyzing the facts, without analyzing the law, because that is an outcome he desires. That is not an outcome that is supported by law or facts. That's how I interpret it.
So you agree with the statement?
Yes, I do.
Okay, it's more or less, your interpretation is more or less correct, partially, in terms of you need to be guided by the law and the facts. But maybe to bring it out clearer, your personal prejudices or your personal beliefs have no place in the outcome, so that often you will find the outcome the law demands may not necessarily agree with what you feel should happen.
That is true.
Yes. So now, as a judge, if you're successful, how will you guard against having your beliefs and your prejudices to affect the outcome of the cases that you handle?
Because I will constantly remind myself that my personal beliefs are not the beliefs of other people. And my personal beliefs should never affect how I dispense justice, how I analyze the law, how I look at the litigants, and how I adjudicate in this particular matter, because that personal belief then does not go into my independence. It affects my independence as a decision maker in that particular case.
Okay, thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Wakili.
Thank you, Madam Commissioner.
Now, tell us the legal framework that is in place to fight corruption in the country.
We have the ASECA, which is the Anti-Corruption and Economic Crimes Act. We have the I don't know if for Kamla, Proceeds of Crime and Anti-Money Laundering. We have Corruption, Public Officer, sorry, that one was repealed, the Conflict of Interest Act, and we have the Leadership and Integrity Act, and I think that is what comes to mind, Madam Commissioner.
So is the framework effective, or what needs to be done?
So far, I think the framework is effective, though with the law, I think we'll always develop. We cannot be stagnant. We have seen cases, at least from my days as a prosecutor, we were successful in most of our prosecution cases in anti-corruption. We have seen in currently where I am, we have seen cases where the finance reporting, there have been recoveries of people who took money that did not belong to them, and it is being returned to the government. I think we are also in the land cases, we are also recovering public property. So yes, I think it is effective, but of course, with every advancement and emerging issues, they will develop more with time.
Okay.
Yeah.
Thank you. I wish you all the best.
Thank you, Madam Commissioner.
Yes, good afternoon again.
Good afternoon, Mr. Commissioner.
Yes, how does community service contribute to social justice and equity?
Community service contributes to justice in the sense that it brings the community like in the case of AJS, we have interactions with the community when it comes to resolving of disputes. Under the community service also there is an interaction, there's a development of or awareness by the community on different ways in which they can approach the judiciary through community service.
What specific community needs have you worked to address?
Community needs, I would say back home we have a program where we have come together as just a few individuals where we identify needy kids who need school fees, who may not be able to afford school. So we contribute towards payment of school fees, or even buying supplies like uniforms and school supplies. We also have church contributions where we give to the church, and the church sometimes then takes these proceeds and gives them to the needy. We also have a program where we contribute towards giving the prisoners utilities. Some of the prisoners, we will provide blankets, we will provide toiletries, but it's a program that runs every, I think it's a quarterly, so we contribute towards that.
Okay, thank you. Thank you very much, Sidia.
Thank you, everybody. I think this brings us to the end of this conversation, Madam Mutai.
Thank you, my lady.
Yeah, but before we release a candidate, we also give them an opportunity to engage us.
First, I'd say thank you for the opportunity to be here. It's a bit nerve-wracking, but thank you for being gentle. And for the exercise that is before you, all graces to you. I know it's not easy.
Thank you.
Thank you.
On behalf of the members of this commission, we wish you well.
Thank you.
And encourage you to continue working hard because you're in the service of the people of Kenya.
Thank you, Madam Chief
We will
Justice.
get in touch with you when we complete this very competitive exercise.
Thank you,
But
my lady.
meanwhile, we wish you well.
Thank you, my lady.
You are released. You can take your writing pad and your water.